the criteria are there. So that's what a care manager would do. That's what I would want to do for this family, to put them in the best position possible, to age positively and to take the stress off of the son or daughter. I don't remember in the scenario that you gave, Barry, who's going back and forth, because they need to take care of their own work and families and stuff. Laurie, did you want to add something?
Well, I think Carol has a question. Carol, did you have a question? I think before. Sorry, Lee, you covered everything. You're so comprehensive.
Hi, everyone. I'm Carol. I worked with Jeremy for all too short a time, to tell you the truth. I recently lost my husband in February. But my question is really for Laurie and or Lisa. I've just recently had my documents done by Yale, by the way. And I'm just curious, do I need something other than a general durable power of attorney and a durable healthcare power of attorney and living will? You mentioned something about a financial power of attorney. Do I need something like that?
That is the general durable power of attorney is the financial power of attorney.
Okay, just because it doesn't say financial, I had to ask the question.
It's just that if you look at so a power of attorney, for lack of a better term, is a document by which you appoint someone to be able to make decisions and handle transactions, and it delineates the powers that they have in the document. That's why and I'm sure Lisa sees just as many documents, as I do. I saw a power of attorney the other day, was so templated, it will get nothing. It's very little that we can work with, in a sense that, more is not always better in life, but comprehensive documents are better to be more, have more clauses. And so this is a big thing that I see. Like I have a couple that just came to me, her husband is already in the active stages of needing care, lacks capacity at this point, we need to do planning, we need to move money into a trust. I have to see the power of attorney to know what I'm allowed to do on his behalf. It is so boilerplate, literally one page, so boilerplate. This is times where this is why I explain to people that put things off of the internet, you get what you pay for, which is usually nothing, in a sense that, and the idea is that it doesn't have even the real estate part, which is such a basic clause that is in almost every power of attorney that somebody attorney didn't use the word transfer, you sold this. So I have to transfer the house, but now I have to sell it for $1 to the wife, who can then transfer it. It didn't even have the word transfer, which just means I could have just given it. So Carol, you're good. And I can't, by the way, ever share who's my client. So of course you see that I was like, really? Okay. I don't ever reveal confidentiality.
Well, I can.
No, you can. You can.
Add something to that, which I'm sure you're working on.
Wait, Lee,
I can't hear you.
Yeah, Lee, we can't hear you.
Can you hear me now?
Yeah.
Okay. So what I'm sure you're working with the Hauptmans. I already explained this to you, but I'm wondering, maybe Jeremy, if you could touch on this. Sometimes, and I know with my clients, I have who have lost a spouse. A lot of the accounts are still titled in the name of either so you're laughing, so you know what I'm talking about. So what I'm going to do, I want to defer to Jeremy right now to kind of talk about that process and the importance of that process.
That cleaning up, yes.
Yeah, because you also want to, before anything happens, you want to take a look, and this is where I said I'm sure the Hauptman's firm has explained this, but you want to make sure that the things that are not going to cost within under the will are titled properly. So those are all the financial accounts. So you kind of, whether while you're, a couple and everyone's alive, you still want to make sure that those accounts are proper titled properly. But it can create some issues when someone is, after someone passes, and you may be dealing with some of that right now. So yeah, I want Jeremy to kind of talk about the importance of the accounts, being properly titled, and then maybe the process as to how you would go about making those changes.
Yeah, I can add to that. So thanks, Lisa. So I just wanted also I echo what Laurie is saying, Carol, about I don't want to disclose who my clients are, et cetera. But since you said that we work together, I guess the cat's
Out of the bag.
But what I wanted to touch on, which is a little bit separate from the financial power of attorney, but it's relative to our engagement, Carol, our interaction.
Mhm.
It's very interesting. Well, it was unfortunate, but when Carol's husband was still alive, do you mind that I'm discussing this, Carol?
Not at all. That's fine.
There was a point in time where action needed to be taken. And we had authorities come to the house, and the first question out of their mouth was, who has the power of attorney?
Mhm.
And thank God Carol had a power of attorney, because otherwise, who else could make, and this was not a financial power of attorney, this was a healthcare power.
Yeah.
Who else can make these decisions if there's no power of attorney? So the moral of the story is it's very important to get those documents in place. And that's something obviously that that Laurie can help with. As far as titling of accounts is concerned, when somebody passes away, and David is a financial advisor with Stewart Partners, and he's somebody who I work with. So you could also jump in here also if need be, David, as far as titling is concerned. When you have a joint account, either one of those people can make decisions. Some brokerage firms or some financial institutions require that both people sign off on an account or on a decision with regard to an account that's jointly titled. Some financial institutions will take one person. Is that correct, David? Would you say that's accurate?
Yes, generally speaking, I'd say the majority of accounts are set up joint tenants with rights of survivorship, which essentially means any of the parties named there can act independent of the other.
Now, when somebody passes, if you have a joint tenants with rights, somebody passes and you need documentation, you need a death certificate. What else would you need in order to create the estate account that it goes into?
Letters, testamentary, it depends.
Yeah.
So if it's a probate asset, I'm sorry, I didn't mean to jump in, David.
That's all right.
We do estate administration also. We kind of take everyone through the whole gamut of their planning. But a big misconception is that everything passes under your will. And I love that Lisa brought that up. It's so important to actually know how your assets are titled. How do you own the bank account? Do you have payable on death, transfer on death? Do you jointly own it with right of survivorship? How do you own your house? As tenants by the entirety, husband and wife? Do you own it as tenants in common, 50-50? All these things make a difference because it controls how things pass. And so it's very important to understand. And so when people die, people think that all their assets pass under the will. Conceivably, in a married couple, sometimes nothing passes under the will because everything was either joint or there was a beneficiary designation associated with it. And so now sometimes I can sort of make as much as possible somebody probate free, which by the way, probate in New Jersey is not difficult, and Lisa could understand this, but understand that, for example, I could have everything payable on death or jointly owned or this, and then they get a refund from the assisted living of the premium, of the month's, deposit or the security deposit back or the CCRC, initial deposit comes back. Then that becomes made out to the estate and you still have to probate. So, and you don't have to be worried. I always think that people get so gun shy about probating. This is not Florida or California where everybody has revocable trust to avoid probate. But it's very important. And what I also tell people is when I do all my estate planning, I give every client what's called a contract beneficiary form sheet. I make them go and find out every one of their beneficiaries and what they say. I had a man the other day do planning for a 40-year-old couple. He still had his mother on one of his small life insurance policies that when he first became employed. People don't realize it doesn't matter what the will said. if I name Lisa on my life insurance policy and I die, even though Yale is the beneficiary of my will, Lisa gets that life insurance policy. It supersedes.
And then
So
can I just, I'm
yeah.
sorry, go ahead. Laura.
No, no,
ahead.
you go. No,
I was
you
gonna
take over,
jump in
Jerry.
and say now, how do you find all this stuff? You need to, where are all these documents?
Yes.
We've got to look through them. We've got to spend time. We've got to go through files. We've got to look at who the signatures are, whose signatures are on the documents, who are the beneficiaries. We need to contact all these people. Everything takes time. And believe me when I say, if you have a life and you have a family and you have obligations, you're not going to have time to do all this stuff. I've done it. And I had to leave my company because of the amount of time that my mother required as far as getting documents are concerned, dealing with, dealing with items in the house, taking care of the house, dealing with bills, etc. So all these things, they all come at you at once, and it can be overwhelming. And having that third party to be able to decipher what is important, what's not important, what we need versus what we don't, is a good benefit to have.
And just to expand on that for a second, I think it's a great point that you're all hitting on here, because so many financial assets and accounts get established over years and decades as opposed to days and months. And very frequently, at least what I find in practice, is people think they've set up certain beneficiaries, and that common misconception, well, I've updated my will. Well, to Laurie's point, all your retirement accounts, all your life insurance policies have named beneficiaries on them. If you've set up TOD, transfer on death planning, that has named beneficiaries. That all supersedes what's in your will. So the underlying theme that I keep hearing here, and I love because I'm a certified financial planner, so I'm a planner at heart, is the fact that you need to have the game plan in advance or very early in the stages that you identify that there may be a familial need. And you can't assume that what you had on one account in relationship is on other. So you do need someone to take that inventory and to double check that all the documents are aligned with the goals and objectives of the family.
I have a question for, I guess, Laurie. Is there a time limit on all of those papers that
Documents?
one would need on the documents?
So if the document is prepared correctly, then it is in effect unless it's revoked or you pass away. But that doesn't mean that it doesn't still fit you. And I always analogize documents to like an outfit. If you have an outfit that's sitting in your closet and you haven't put it on in 7 or 8 years, it may not fit you anymore. And that's how I feel about documents. You need to take them out, because Lisa gave the perfect example. The person named their vet. I have people that, for example, have documents where they name their spouse and the spouse is either no longer alive or they have dementia. So if they don't have a successor alternate, then that document is moot. It has no power because there's nobody else after it. So I recommend that people update or at least look at their documents every 5 to 8 years and see if it still works. It doesn't mean it will be. And another thing is that financial institutions push back on stale documents. Push back, they're not always correct, but they will say, this document is 20 years old. And so they'll say, we want some kind of affidavit saying that it's still in effect or it's still. Now, if the person lacks capacity and they can't execute a new one, believe me, I go to bat to say it's valid under the statute, but they get worried, financial institutions. And so we do recommend that if something is very old that you update it. Another thing to be aware of is please don't confuse a general durable power of attorney with a power of attorney that you may have completed for an individual institution. So just say you have somebody that works with David and their company says, or previously said, you can have a power of attorney for our company, but that document will not